Hello, Mr. Waldman. Welcome to our TV show. How are you doing today?
I'm very good, thank you.
Great. Now it is my pleasure to introduce you to our viewers today. They are waiting to hear from you. Tell us about your role as a counsel for the Federal Court Appeals at Singh & Associates.
Well, I know Singh & Associates for many years. I know the principals, Tajinder and Parminder, very well. And they approached me some time ago and asked if I could assist them with federal court cases. And I've been doing federal court cases in the federal court in Canada for well over 25 years. So when Tajinder asked me and Parminder, I agreed to work with them because I know the reputation and I felt comfortable agreeing to help them in federal court cases. So that's how I've gotten involved with Singh & Associates.
Okay, great. Now, people are scared in India by the name of courts. They have perception that once a case goes to court, it lingers there for years and sometimes 10 to 20 years. And how can you dispel this perception of courts? How much time does it take in Canadian courts to resolve a case?
The situation in Canada is different. You know, it's true that there are some cases that take a long time, but generally speaking, immigration cases have a special set of rules, and the idea is that the cases are supposed to be decided very quickly. In all immigration cases, you have to do a two-step process. The first step requires you to apply for leave to go to court. It's called leave to commence an application for judicial review. And that is governed by very strict timelines. You have 15 days to file the application if it's a decision in Canada, 60 days if it's a decision outside of Canada. Once you file the application in the court, you have 30 days after that to file the written submissions, called the record. After that, the government gets 30 days to respond, and then you get a final 10 days to make a final submission. So everything is done usually within 3 or 4 months of the decision being rendered. A judge of the federal court will look at the application for leave, and usually within a month or a month and a half, a decision will be rendered. If you get leave, the leave has to be decided and heard within 3 months. So a lot of cases that I'm doing now in the federal court, from when we start the application until we get a decision, it could easily be not more than 7-8 months. It could be sometimes a bit longer, up to a year. But in immigration matters, it's usually done very quickly. So I think your viewers should understand that it's not always as slow in Canada as it might be in India.
Right. In most of the rejected cases, the refusal letter says the client has no right of appeal, the refusal decision. Now, if there is no right of appeal, why would a client seek your assistance?
First, we have appeals to the Immigration Appeal Division from a refusal. In some cases where people sponsor close relatives, they have a right of appeal. So when the letter says you have a right of appeal, the appeal doesn't go to the federal court, it goes to the Immigration Appeal Division. And it's a different procedure. And so that's when you get an appeal. If the letter says you don't have a right of appeal, what that means is you don't have a right of appeal to the Immigration Appeal Division, but you always in immigration matters have a right to seek judicial review. So the judicial review application is the application that's done to the federal court, and that's where I get involved in the case, because only a lawyer can do federal court, and I've been doing that for 25 years.
Now, for this reason, most of the clients don't even appeal or approach a lawyer. Do you have any comments on the Immigration Department's misleading practice?
Well, I think in some cases the letter should be clearer, and if it says there's no right of appeal, it should indicate that there is a right to seek leave or judicial review in the federal court. And so I know that sometimes the letters say that, and in the cases where they don't, it should be stated clearly, because people outside of Canada aren't aware of the legal system in India, so it should be clearly stated in the letter. And to the extent that the letters don't indicate that there's a right of appeal, that's not correct.
Don't you think that the refusal letter should say that the client has no right to appeal, but the client can appeal the decision with leave of the federal court, or simply that the client has right to seek the leave of the federal court of the judicial review of the rejection?
I know that in some cases the letters do say that. I think they should say it in all cases. So I think it would be more appropriate if in cases where there is no right of appeal, the letter clearly stated that there is a right to seek judicial review.
What is the difference between an appeal and a judicial review?
An appeal goes to the Immigration Appeal Division of the Immigration and Refugee Board. It's a new hearing. You can present new evidence and you can testify in person before the appeal. A judicial review is not an appeal. The judicial review is based on what was the information before the immigration officer who made the decision, and it's, as I said, first it's a written appeal to the judge to see if there's any serious issues, and secondly of all, if you get leave to appeal, then you get an oral hearing. But it's not an appeal. You can't call new evidence. It's a decision that's based upon the record that was before the immigration officer. So it's much narrower in scope than an appeal. So obviously it's better to have a right of appeal than it is to have a right for judicial review. I think it's important for people to understand that in the case of appeals, those are even matters involving the family class. If a person sponsors their relative, their mother, their father, their sister, their brother, their mother, their father, their wife, or okay. So so I think it's important to understand that in a case of an appeal, appeals arise when in sponsorship applications, where you sponsor a member of the family class. So if you sponsor your wife or your husband, your children under 22, or if you sponsor your parents, and the application is refused, then you have a right to appeal to the Immigration Appeal Division. And that is a full appeal where you get to present new evidence. In every other case where it's not a sponsorship application, so that could apply to skilled worker applications, experience class, entrepreneur, investor applications, people who are applying for work permits, for visitor permits, all of those applications, there is no right of appeal. So in those cases, you have to seek judicial review with an application for leave in the federal court.
How much percentage of the cases are rejected?
I think it depends. If you look at the statistics of the federal court, leave is only granted in about 15% of the cases. But that's a bit misleading because there are a lot of people who file the applications for leave and then they don't file any further evidence. So that really alters the statistics to some extent. The other thing is, in our office, we don't take every case. Before we decide to take on a case, we have to look at it carefully and decide whether we think there is any chance of success. So because we review the cases first and only take the ones that we think have a good chance of success, our success rate on applications for leave is much, much higher, well over 50%, and I would say probably over 70%. We usually get leave in most of the time. But that's because we go through a screening process before we decide whether or not to take the case. So normally if someone approaches us and says they want to go seek judicial review, we ask them to send the information. We review the information for a small fee. And if we think there's a good chance of success, then we agree to proceed with the case or not. And that increases our rate of success on the appeal.
And why do you think the cases are rejected? What are the causes of refusals? Is it because the client or his representative made a mistake in filing the application, or is it because the visa officer made a mistake?
I think, it depends on the case. I've seen a lot of different situations. Unfortunately, in some cases, the mistakes are made by the client or by the representative who started the application. If they've made a mistake and they haven't filed a document that is required, then oftentimes there's not a lot we can do. I'll give you an example. Let's say you apply as a skilled worker and you want to get points for having a relative in Canada. Well, the instructions say when you file the application, you have to present all of the documentation. So part of the documentation you need to present is evidence to prove that your relative is living in Canada. Now, if the consultant or the person doesn't give the evidence, doesn't give proof that the person is living in Canada, job letters, utility bills, phone bills, other evidence that shows that the person is really in Canada, school records for the children, things like that, and then the visa officer says, well, I'm not giving you the 5 points for relative because you didn't give the evidence, then there's often very little we can do to challenge that decision. If, on the other hand, the applicant presents everything and the immigration officer makes an unreasonable decision, we can often be successful. And I've seen both. Sometimes there are cases where there's absolutely no reason for the application to be refused, and it's just refused unreasonably, and usually we're successful in those. We deal with those cases all the time. But other times, the application is refused because the person who made the application or his consultant didn't give the information that's required. And if that happens, then the chances of success are probably not very good. And we often would advise the people not to appeal, but maybe to submit a new application.
What are the preventive steps a client must take to avoid litigation?
Well, I think, the best advice I give to anyone is make sure you do the best application possible, And usually that means getting the best advice from a competent consultant or lawyer who knows how to prepare the application and prepares a good, complete application. Because if we prepare a good, complete application that has all of the information that's required, it shouldn't be refused. And if it is, then we have a good case for litigation. So the best advice I can give is to make sure you complete your application fully and put all the evidence in. And if you're not sure how to do that, get good advice.
Is there a time limit within which a client must file an appeal in the court?
There are 2 time limits, one for decisions that are taken in Canada and one for decisions that are taken outside of Canada. The idea being that if you're in Canada, it's easier to find a lawyer, so you have less time. If the decision is in Canada, you have to file the appeal within 15 days of when you get the information. If the decision is outside of Canada, you have to file the appeal within 60 days of when you get the decision. If you miss the deadline, it is possible to apply for an extension of time, but those are not that easy to get, and it should be avoided. If you find yourself missing the deadline, then we can apply for an extension, but we should do our best to file the appeal within the right time periods.
What can a client do if an overseas lawyer doesn't work on the case and they just run away with the money?
Well, I've heard of a lot of cases like that, and indeed, I've been receiving calls from India about people who claim to be my agents in India, and I can say I have no agent in India. The only people that I am associated with in any way are the Tajinder Singh and Parminder Singh, and I'm associated with them for the purpose of assisting them as counsel in federal court matters. And people call me up and saying that people are promising that they're working for me and they're going to help them get work permits. That's not true. I'm not associated with anyone. And I've seen other cases like that where people promise to apply for visas and they don't. Unfortunately, if that happens outside of Canada, there's not that much that we can do here in Canada. The only thing that can be done is the person should go to the police in India and report it, because that's fraud. At least it's fraud in Canada, and I would assume under the Indian Penal Code, promising to provide a service when you have no intention of providing it and then taking the money would probably be fraud there as well. So I think if a client finds himself in that situation, they should call the police immediately and make a complaint.
Do you have any interesting examples from your experiences from which our clients can learn?
Well, I've been successful in many, many cases. Sometimes we can be successful because the visa officer was unfair in how they approached the case. For example, I was involved in a case recently where the visa officer decided that some of the documents were fraudulent, and he didn't notify the person that he had suspicions about the documents. And so I went to court and said, well, that's not fair. If a visa officer gets a document and it meets the requirements, but the visa officer has a suspicion, in order to make a decision, before you can do that, you have to give the person an opportunity to respond to the concerns. And we were successful in the court in that case. There have been many other examples. Some examples where visa officers have found that people are inadmissible because they misrepresented facts, and in fact we were able to establish that the people were telling the truth when we got the documentation and presented it in the court. In other cases, visa officers have said that